Members, we'll now go to a grouping considering the Paturoa Road kauri tree or trees and its possible protection. And if I can just remind you that in response to this delegation here today, a memo was distributed, I think it was last Tuesday. Hopefully you might have that on your desk. And I will hand over to the parties. Now, Steve, would you like to introduce and then introduce your colleagues? And I think you're about to present collaboratively together, and if we can just make sure that we don't repeat in the various parts of the presentation, because I think we know exactly what you're asking for here today.
Right.
But with you, Steve.
Thank you. Steve Abel, speaking for the Save Our Kauri Trust. We have Mels Barton here speaking for the Tree Council, and Chris Pairama for Mana Whenua Ngāti Whātua. And Mels will begin, and then I'll speak, and then Chris will conclude. And we can take questions at the end if that's easier.
Kia ora koutou, councillors. Thank you for having us to this meeting. I'm from the Tree Council, and I'd like to refer you to the letter that's been circulated to you that was sent by the Tree Council, Forest and Bird and the Waitakere Rangers Protection Society. It raises a number of issues regarding ways in which we believe the Council can better protect trees in the Auckland region under the legislation that you have without requiring new legislation. Today, we're just going to address in this 5-minute presentation the most urgent of the issues raised in this letter, but we're really happy to come and talk to you again about the other issues at some other time if that is appropriate. The situation that we're going to talk about is on Pachiroa Road in Titirangi, where at least 3 kauri are at risk. One of them is on private land at number 40, Pachiroa Road, and then there are 2 really large ones on the road reserve. The kauri on Pachiroa Road number 40 is currently only protected by an interim injunction of the High Court. But the road reserve trees are on public land and they need consent to remove them at the moment. Prior to 2015, all of these trees were protected by general tree protection until that was removed from the RMA, and then they were within a significant ecological area, an SEA, until 2015. So this is a photo of the 2 road reserve trees on the left-hand side. So you can see they are really quite substantial. And the tree on number 40, which was named Awhiawhi, and that photograph's taken from the neighbour's property. Oops, sorry. This is a picture of the SEA in 2013. So as you can see on number 40, the SEA covered the entire section of 40 and 42. And those 2 sections substantially covered with trees and the road reserve. And the SEA extending over the road reserve, as you can see. Oh, sorry. So what happened was that in 2014, developers Lenihan and Greensmith obtained non-notified consent to remove trees and develop on 40 and 42 Pachiroa Road. And those consents were gained under the Waitakere District Plan. The tree removal began, but it was stopped by a public campaign to save these kauri trees. There are a lot of kauri trees on this site before the removal began. And that public campaign was supported by 26,000 people who signed a petition and a number of politicians who were campaigning for election at the time. You might recognise some of them. So Lenihan applied, at the time that the unitary plan was in process, he applied to the unitary plan to have the SEA removed from 40, 42 and the road reserve in 2015. Council's ecologist, Jane Andrews, she presented to that hearing, and she stated in her evidence that the remaining vegetation on the site that hadn't already been removed still qualified as an SEA. So here is Jane's statement. These trees are contiguous with the remaining vegetation on site, as well as vegetation within the wider area, and in my opinion meet the SEA criteria for representativeness, Kauri Podocarp broadleaf forest, and buffers a protected area, the Patara Esplanade. Although the submitter has consent to clear this vegetation, it had not been completed at the time of my site visit, and my assessment is based on the current extent of vegetation. That vegetation that she believed constituted an SEA still remains on the site. So because at the time the developer had consent to remove that vegetation, the council lawyers overruled Jane and told her that because he had consent to remove, then the SEA could be removed. I'd just like you also to note that the SEA was removed from the road reserve, despite the fact that this developer never applied for or ever had any consent to do any work whatsoever in the road reserve. So this was what happened to the SEA on 40, 42 and the road reserve. It was removed. And that's a picture of the trees that still remain within that area. As you can see, it is still well treed. So then what happened? The neighbours took a judicial review of the gaining of the consents, which were got non-notified. And during that High Court judicial review, the developer voluntarily surrendered all consents for those two properties. So there are currently no consents whatsoever to do any work on these properties in existence. There never were any for the road reserve. The two consents for 40 and 42 have been surrendered by the developer. However, because the SEA has been removed already and general tree protection had already been removed from the RMA, there is no protection for these trees other than the High Court injunction that was placed following the High Court case. So if that High Court injunction is removed, then the tree on number 40 can be cut down, just like any urban tree in the city that has no protection under the RMA. However, if new consents are applied for under the unitary plan, because we have the unitary plan now instead of the Waitakere district plan, they must comply with the rules in the unitary plan for setback. And the rules and setback require a 10-metre setback from the front boundary. So you cannot place any buildings within 10 metres of the front boundary. The tree, the kauri tree named Awhiawhi, on number 40, is within 10 metres of the front boundary. So there's a map of the road reserve with the two large kauri in the road reserve, the front boundary, a 10-metre setback, and there you can see that Awhiawhi, its entire drip line, is well within 10 metres of the front boundary. It is within the 10-metre setback. No buildings can be placed within that 10-metre setback. This tree is not preventing development on this site. They could not put a building there anyway. During all of this tree was ring-barked. It was, and my colleague Chris will talk about this, but the ring barking took place. The tree was treated with Mātauranga Māori techniques. After 3 years, this tree is still alive and flourishing. It's also on a site that has kauri dieback. This tree does not have any obvious symptoms of kauri dieback, neither do the two in the road reserve. We have Auckland University scientists very keen to do work on why this tree in particular that's had the Mātauranga applied to it is flourishing. Dr. Kate McGuinness-Ing is here, and obviously this tree needs to stay alive for this work to take place. In court, in the High Court, the developer agreed that this scientific research could take place on this tree. Here is the roranga being applied. So what we are asking council to do is to include a proposal to replace the significant ecological area, remembering that the vegetation that still exists on this site does constitute a significant ecological area in the view of Council's own ecologist, into the plan change that you already have in train to look at the schedule and protect trees. This plan change will be publicly notified. Everyone can make submissions on it, including the developer, council, and the public. This is something that was never able to happen when the original consents were issued non-notified. No one could make submissions. But on a plan change, obviously, it's publicly notified. So the decision regarding this significant ecological area status replacement on this site will not be made by you sitting around this table. It will be made by the independent commissioners hearing that plan change. So council itself will not be setting any kind of precedent in terms of doing this. You will not be siding with or against the developer. You will just be enabling a public process or a discussion about whether to replace the SCA on this site or not. You are basically levelling the playing field, recognising that the premise for removing the SCA in the first place, i.e. the consent to remove vegetation, no longer applies. So why should you do this? Because that premise upon which that decision to remove the SCA was based no longer applies. Those consents have been given up voluntarily. There are no consents. We believe that the removal of the SCA in the road reserve was in error anyway, because there was no consent applying at the time for work to be done in the road reserve. There was no consent ever applied for. The tree on private land is special because it has been through the ring barking and it has had Mataronga applied to it, and we believe that that is special. The unitary plan rules under which new consents will be applied for are now different to the Waitakere district plan rules upon which the old consents were based, and therefore the 10-metre front boundary setback applies, which means that the tree is not in the way of any buildings that will eventually, presumably, be put on this site if it is developed, because they have to avoid the 10-metre setback. And if you don't do this, Lenehan will remove the kauri and all the other trees on 40 Pacharoa Road as soon as he can. He has already obtained a certificate of compliance from council that states he can do this. So his intent is very clear, that he will remove this tree, despite the fact that he does not need to do this in order to develop his property, because he can't put any buildings in that 10-metre setback. There is a High Court case ongoing at the moment, an appeal on the lifting of the Environment Court's ruling to lift the enforcement order. The reason why the enforcement order was ruled to be lifted by the Environment Court was that there was no process in place in order to replace long-term protection for this tree. That is what I am here to ask you to put in place, a process to restore long-term protection for these trees by the SEA. That is effectively what the Environment Court ruling said, that the remedy is a plan change in accordance with the legislation, i.e. the RMA as it stands, which enables you to have significant ecological areas. Also, I believe that council, in not replacing the SEA onto a piece of land which has vegetation that qualifies as significant ecology, is devaluing the SEAs that you have around the region. There may be other instances in which SEAs have been removed, or in which SEAs could be placed or have been applied to be placed, which you could also consider via this plan change, and that's one of the things that we asked for in the letter. But we also know that Lenehan will apply for consent to remove the road reserve kauri further down the line. That's very, very likely. Once, if he gets consent to develop these properties, he's going to want those two big trees gone that are on the road reserve as well. And whilst they are currently protected by being on the road reserve, if they have SEA status placed over the top of them, that is an additional level of protection. It's a much stronger argument to make that these are a significant ecological area and should not be removed. So this is an area, Pacharoa Road, this is an area in which kauri dieback disease is rife. These three trees are significant in size. The two road reserve trees are extremely large. It would be a crying shame to allow 3 healthy trees to be removed from a road that has so much disease. I will also refer you to the affidavit by Edward Ashby, who at the time was the general manager of Te
Nels, can we bring it to a wrap, please?
And he stated that the Rahui it applies to the entire forest, not just the regional park, and that obviously these trees are within the forest, and that the Rahui requests protection of kauri within there. So thank you very much for considering this proposal. We would ask that you request a report from the staff to include a proposal to replace the significant ecological area on 40 or 42 Pacharoa Road and the road reserve in the upcoming plan change that you already have in train regarding trees. And thank you for recognising that the environment matters as well as development rights in getting good outcomes for managing Auckland's land. It is a balance. This is a significant ecological area. It is not just about packing as many trees, houses onto that site as possible. Thank you very much.
Thank you, and both Chris and Steve are available to take questions as well as Mel. Can you deactivate the microphones there? Just one at a time when speaking, that'd be great. Steve, can you deactivate yours? Thank you. Now, I just need to allow our Director of Strategy to give us a bit of background here. And if you could also reflect on the memo that was distributed on the 29th of May, members. Megan Tyler. Oh, sorry, just before you do, Megan, your presentation showed a photo of Mayor Goff and he had just left the room. We've just received a message that one of our councillor colleagues, her mother, is very close to death right now, and the Mayor has gone to support the councillor.
Kia ora, thank you. Look, just following on from the presentation, thank you, Mels and the team. In the memo, I just wanted to just put a few key facts in there as well, and then happy to help to answer questions if that would be helpful. The key thing here is that this has gone on for some time, and there has been robust and legal process throughout the whole length of this issue. Nothing that council would do from now on will be retrospective. That is, the applicant can remove this tree as of right, our certificate of compliance, as Mels has mentioned. And so even if a SEA or anything was put on the property, it wouldn't affect the ability of the tree to be removed anyway. That's law and that's case law. From staff's perspective, given the process that has been put through through the unitary plan, independent hearing panel process, and the courts, it is our view that there is nothing that we can do or should do at this stage. It is where it is. This matter, there is development rights on this property. This property will require a building platform anyway, so the whole SEA would never apply to the site anyway. There would still need to be the ability for buildings to be built and access ways and all of the stuff that is around a building, not just the building itself. So it's our view that there is no need or interest when we take up the whole benefit and cost of doing work on just this property. There is no need to do any further work on the SEA or the tree protection for this property, but happy to clarify anything as councillors ask.
So if we just clarify then, the scope of what we resolved and the date, I think, was, what was the date of that one, that resolution there? Sorry, early April this year, moved Councillor Walker and Councillor Hull second, and that was to prove the notification of a plan change to look at the technical errors and anomalies. Now, at that time, I'm sure we discussed this very issue, and there is no scope in the way that has been notified. It has already been notified.
It's going to be notified in June, so very shortly.
It's about.
And it is yes, it's just a cleaning up of the schedule. It's not adding or deleting or changing the trees on that schedule. So it doesn't. Neither is the scope include SEA or the significant ecological features either. That's a separate part of the plan, and it's not part of the scope of that plan change.
And then just separately, there's a suggestion that there's no protections on the kauri. There's two kauri on the road reserve. Can you just go over that again, please, just to make sure that we are aware of the protections, and some might question the level of protection. But if we could just identify clearly what the protections are and what the process would be if somebody sought to remove those trees.
So currently the protections are that it requires a resource consent through the unitary plan to remove any tree on a road reserve. And so that's a resource consent that may be notified. Again, that's a case-by-case decision on that. And we would look at the purpose for the trees being removed. We would talk with Auckland Transport as well. And it would go through that normal analysis and process through the resource consent.
Thank you. Now we'll take some questions. Councillor Newman, please.
Good morning. I understand the discussion around the trees on the road reserve. Get that. My issue is the kauri at 40 Paturua Road. I wouldn't want to see it. I wouldn't want to see it felled at all. It's beautiful, but I don't own the property, and no one in this room owns the property. The property is owned by someone who wants to exercise a private property right, however egregious I might consider those actions to be. So my question is, what property rights should that owner enjoy, and what private property rights need to be extinguished? Where do we strike the balance here, understanding that the tree is on someone else's property, they have rights, and I don't feel that I have jurisdiction to try and extinguish those rights. That's a decision set down by Parliament.
Thanks for the question. So we are not against the gentleman executing property rights. The balance has to be struck between the broader ecological value of a 350-year-old Kauri tree, as assessed by Kate McKinnison, Associate Professor from Auckland University, who's with us today. A tree that's been standing longer than any of us with Pākehā ancestry have trod on these shores. And there is a balance to be struck. There is no need for this tree to come down. As Mel's pointed out, it's within the 10-metre setback. There is a way that you can build, as most people build in the West Auckland, with maintenance of the integrity of those large Kauri trees that are a collective treasure of our society and our city. And it's important to point out here that the council has facilitated the interests of this developer every step of the way over the last 4 years. The City Hall has been against us in this fight for this Kauri tree. There's been a lot of hand-wringing, a lot of, oh, we're sorry, we're powerless to do anything. But the fact is, the council has gone to every effort to facilitate this guy's right to cut this tree down, including most recently on the 11th of April with the rapid issuing of the certificate of compliance saying, everything's fine with it, cut it down, mana whenua don't care about it, no mention of public interest, no mention of petitions, no mention of scientific value. And the main point I would like to make, if I would make one point here, is that if there is not a will on the part of this council, a genuine will to try and save this tree, then this tree is gone. And there has not been a will. This council has collectively let hope die in the middle tier of council bureaucracy around this Paturua Kauri tree. And so this is the last chance to save this tree, because we as a community cannot beat City Hall if you're against us. We want you to support the High Court appeal that's in place now. We want you to genuinely look at putting this SEA back in place. But in fact, by whatever means necessary, there has to be a resolution found whereby this tree can remain standing, and also this gentleman can have his right, some development rights there. There is a balance to be struck, but if you're not with us in the goal of protecting this tree, then the sap of this ancient Kauri tree will be on your hands. Because we as a community, and as mana whenua, have done everything to save this tree, but we cannot beat you if you're against us, and so far you have been. So our message to you today is to stand with us, to find a solution to save this tree.
Everything bar buying out the property owner. I mean, if the one remaining thing to protect this tree is to buy the right to the property, that seems to be the only thing left. Because frankly, what you've said I think is very powerful, but it doesn't address the fact that the land is privately owned and the property owner enjoys the right to be able to develop that site.
But it's
So-
not a blanket right, is it? I mean, you don't have a blanket right to do everything you want on a property. There are
I would suggest
protocols around protection of environmental values and so forth.
I'll just allow the councillor to conclude the question.
So does this have to conclude, if need be, that in order to exercise the prerogative of protecting the tree, ultimately the property owner has to be bought out? Because I can see nothing else more certain than enjoying the right of that property, and short of doing that, I'm not certain that anything that you're suggesting here today is going to save that tree.
Given that the tree lies within the 10-metre setback and no buildings can be placed within that 10-metre setback, there is nothing regarding the survival of this tree that prevents that property owner exercising his development rights under the unitary plan, because he has to comply with the 10-metre setback. Sorry?
Well, he might not want to build there, but he might just want a front. I don't want to see the tree felled. I don't want to see it at all. But I'm saying that, the ownership of the property bestows on the owner certain rights.
Only if the planning scheme has the protections in it. The problem is that the unitary plan commissioners, on application from the landowner, removed that protection of the significant ecological area because he wanted it removed in order that he would have no restriction to remove any tree on that site. That's the issue here, that was removed, and now those trees, because the RMA has changed as well, those trees now have zero protection, whereas in fact they still constitute a significant ecological area, and he has no consent to do anything on that property. So he currently has no development rights on that property, okay? Because he has no consent to do anything on there. He has no consent. So as in exercising those consents, he needs to apply for new consents. That's not a given. He might own the property, but he actually has no development rights on there because he owns no consent to develop that property. And so to say that any of this is preventing him from doing anything, no, he has no consent to do anything on that property at the moment. Until he applies for new consent, he can't actually do anything. So if the SEA is not put back in place to protect the vegetation as it stands, then when he goes back onto that site, he can remove all of it. And that, as Steve points out, that's not the way in which development is done in Te Tarangi, because of the trees, which do also hold the road and the slope and the neighbouring property. It's a very steep site. It's a very steep site. So those trees are very important for holding the road and the neighbouring properties up at the moment. Otherwise, they're all going to end up in Patriarch Bay.
Just take this opportunity to have some comment from the Director of Strategy.
I just caution councillors to get too discursive about private property rights. The unitary plan does provide development rights in these kinds of sites. By even if there are SEAs, there needs to be the provision of a practical building platform, and this is what the last years have gone through, is to determine where practically, given it, as Mel's has said, it's a very steep site, where some development could practically go. Yes, there would be consents required to get to the fact of the act of building, but there are development rights on this site, notwithstanding whether or not there are consents right now to actually physically build. The certificate of compliance does allow this developer to remove the tree and that cannot be extinguished even if we put an SEA on it. It would still apply. Hence my advice to you is that there isn't, this suggestion is not going to help this situation. And so I hope that's clarified. I just would perhaps not talk too much further around development rights on this property. There are some.
Thank you, Councillor Newman. Councillor Casey, please.
Thanks. I've got two questions and I reserve the right to speak. And my first question relates to the fact that this isn't a tiny little local issue, that you mentioned a petition of some 26,000 signatures. I'd like you to talk more about that, and also the fact that the tree has been lived in for substantial periods, which ended up in court, and our Michael Dearley, I don't think he got a fine in the end. I'd like to hear about that. I think it's important. I'd also like to hear from Chris. This tree was ring-barked and it's been saved. And I want to know how you did that. And I want to know about the university research that's going to look into that. I think it's incredible. It's an incredible thing.
Chris, do you want to comment?
Tēnā koe e te whare. Te mare e te komiti o planning. Tau whare te maunga, wai patu kahu koe awa ka rea tū ko kaipara te moana. Whiti tērā o rewiti te marae, ko te hāpū te tau, ko te iwi whātua. Kia ora koutou. Just at this time, forum, I just asked to show a little respect for a recently passed former councillor, Councillor Neil Abel, being Steve's father, and I culturally and ask also that we have a memory at this time for that particular situation. Thank you. And I might just sit down and continue. Actually, no, I won't. So, yeah, we can go to the next slide now. Oh, is the rako there? So, kauri are spiritually significant to all Māori. Each individual kauri is unique. If a kauri is cut down and support an ecosystem of approximately 150 creatures, flora and fauna is removed. Each year, Awhiawhi produces thousands of seeds which are unique to this ecosystem and the surrounding bioregion. These seeds are imperative to the survival of Kauri. I just wanted us to take a little time and understand the landscape of Kauri. Our Kauri trees are nationally under a significant threat from Phytophthora agathodista. It is a Kauri killing disease, and the Waitakere Ranges is the most significantly harmed for that. So right at this juncture, for me and for us, every Kauri tree is significant. And this is a conversation that was evoked by the environmental judge, Smith. What is the significance of this rako? So I'll continue. In March of 2015, I visited Pataroa when called by the community as mana whenua. Ka mātua from Ngāti Wai joined me in the karakia, and a tapu was placed over Awhiawhi. Should we go again? So, next, Mel. So that was a picture of the ring barking. Now, Lenehan, the owner of the property, allowed this situation to happen. A number of trees, including Awhiawhi, sustained extreme trauma after being ring-barked on the 23rd of December 2015. So I got the call on that morning, and then I rang my cousin, and my cousin talked to my cousin. And then in the afternoon, they applied a kawakawa poultice whilst I recited krakia to the internal cambium of the tree. Now, successfully enough, it wasn't a complete ring bark because of the steepness of the slope. So if that person would have been successful, perhaps we wouldn't have a tree to talk about today. but he wasn't. After applying that poultice and applying kawa leaves on the outside of the poultice and making sure that significantly that rako was watered every day, this tree has survived, amazingly enough. So this tree is a living example of the healing nature of our runga and must be preserved. Runga being medicine. Thanks, Mel. So, yeah, there she is again. Wonderful, wonderful, happy. Okay, carry on. So, I formally hold Te Rā o Rewiti Marae and Te Tau Hapu. Our marae is the closest ancestral marae to the Waitakere Ranges. The Tangata Whenua o Rōpū is included in the National Management Program for Kauri Dieback via the Ministry of Primary Industries, which has acknowledged the value of Mātauranga Māori. So a decade I've been part of that on behalf of my people. This knowledge is forming an effective response to Kauri Dieback research and is currently at the forefront of the scientific community. Please ponder that this is very, very contemporary, and this development work is actually attracting global interest. The resilience of Awhiawhi combined with her ability to withstand ring barking, along with the healing that occurred, affirms the value of Awhiawhi to whiti te rā o Rewiti Marae, Te Tau and Mātauranga Māori. Mouse. 3 mature kauri grow together as whānau. All 3 kauri are of significant cultural, ecological and scientific value. Now, Forum, I've heard a lot of talk about laws and the like, laws of which never existed when this rako was breathing. A 350-year-old individual asks that she be left alone. The carbon sink that's provided by the 3 trees is also very significant when you add them to the many, many kauri all over the land. And echoing Tani Mahuta from Waipo, the 4th largest tree on this planet, 2,000 years old. This is the whānau. Just stop and take a breath, Council. Please, we ask. Standing by the community as mana whenua, myself, my tupuna have walked that land hundreds of years. We say no. Leave that rako alone. Find a different way. Surely we can find a better way. So thank you all, whānau. I think we might have a little song, eh? A little waiata. E aroha te whakapono me te rangi mai e tātou tātou e te aroha te whakapono me te rangi mari e tātou tātou e. Kia ora koutou everybody. Thank you.
Kia ora, Chris, thank you. We'll carry on with questions. Councillor Wayne Walker, please.
Question of Mel's, and it's about the tree, and I understand the spiritual value of the tree and the like. I guess I'd put to you that arguably our tree protection is out of step. Overseas, for example, UK, Germany, there are scales for valuing trees. They put a dollar value on the tree, but that's as a consequence of many, many factors, and trees can be worth tens, sometimes hundreds of thousands. Has any work been done around these trees, particularly the age of the trees and the significance?
Dr. Kate McGuinness-Ling is here, and I'm sure she would be able to answer that question directly about the age of this tree.
Kia ora koutou. Kate McKinnison from the University of Auckland. I've been providing expert evidence around Awhiawhi and the other trees in this case throughout the process. So my expertise is in tree physiology. I work on what do trees do for us and how do they make a contribution to the ecosystem. I'm particularly interested in carbon uptake and storage and also water use. So I think there's two things important to this case from my perspective as a scientist. The first is that, as Mel said, the site is very steep, and trees like this are just so important for binding the landscape. It's not just about the roots themselves. Kauri have very deep roots, which are really important for holding the landscape together. They also have very complicated canopies. So those canopies act as a massive umbrella, and they catch any rain that comes into the system. And in a closed forest, we can see up to 44% of rainfall will be captured by that canopy, and it's then evaporated back out into the atmosphere. We call this process interception, and it means that there's a whole lot less water coming down into that system throughout the year. So they're binding the soil, they're preventing water coming into that soil, and the other thing they're doing also is using water from the soil. So transpiration, trees of this size use hundreds of litres of water per day. So they're removing that water from the soil, keeping the soil not too damp, and making sure that the system, the hydrology, is really healthy. And as Mel said, that's so important for keeping that landscape in a good situation. The other thing I would say is around the tree and its situation at the moment. I'm involved in global analysis of tree mortality. So globally, large trees are in decline. And by large trees, I mean trees that are larger than 60 centimetres in diameter. So this is sort of, I guess, this kind of size, if we want to put our arms around a tree. And these trees, well, Awhiawhi itself is 98 centimetres, so nearly a metre in diameter. It is very much within the large tree perspective. And as I said, these are in decline, but what we're trying to do is look at mortality processes. So this tree is just fascinatingly interesting because we've seen it take a huge amount of damage, but it's surviving somehow. So there's some stuff going on here that we want to keep looking into. Each one of these trees has so much value to the landscape. And in talking to how do we sort of put a monetary value on these trees, I mean, people talk about, well, how much water it uses, the carbon it takes up, but actually the protection that it's giving to the landscape, that is worth in itself tens of thousands of dollars in protecting the properties below those particular trees at the site. So it's really difficult to get a really accurate number on those things. And then I would say, of course, that the cultural and ecological significance, sometimes putting a monetary value on these things is just not at all possible.
And I have just one other question. So Councillor Newman, for example, raised the issue around purchasing the property. Have there been any discussions with the owner? Is there any inclination to sell, particularly given the public interest?
I don't know any detail of that. I do believe there have been approaches made, but I think on a private basis. And my understanding is the developer wants a very large amount of money for the properties, much more than he paid for them. And there's been discussion of transfer of development rights as one potential solution. But I think the thing is that we need to have a willingness on the part of the council to help facilitate a resolution or a solution. And without that, this sort of washing the hands of it type talk we get, that will mean the tree will come down. This man is intent on cutting the tree down. The only thing that's stopping it from being cut down now is an injunction at the High Court because of the High Court appeal of the Environment Court decision. And if, as Megan has said, the certificate of compliance would trump any reinstatement of this significant ecological area, then our appeal to the council would be, therefore, join us in this High Court case. Let's test whether the conclusion of Judge Smith in the Environment Court was correct. Let's find out whether there shouldn't be protection there, because the only thing that is keeping that tree protected is that injunction because of the community case, which we are desperately trying to fund through Give a Little right now. And if what Megan is saying is that the certificate of compliance, which was so rapidly issued in that little gap between the case on the 4th And the appeal later in April, that certificate was issued on the 11th of April. And while a notable tree status application that's been sat on a council desk for 2 years now has been unanswered, the minute there was a High Court, Environment Court decision, the developer was in there and council very quickly produced the document he wanted to say it's all fine with us. And so this is yet another example of where the council has time and again sided with the developer, has not sought a way to find a middle way where we can save this tree and he can have development rights. And really, if there is not a will here at that council, I'll say again, we can't beat you.
So just on that, Steve, I'd say from my experience of dealing with this particular issue, there's tremendous willingness to examine all the options. And I think you are aware of all the options that we've examined on this. And I can tell you that I've taken submissions from Councillor Hulse and Councillor Cooper on this, and together we've sat down with the staff on at least half a dozen occasions trying to find a way. Now, I wouldn't say we have our hands tied, but the window, an opportunity for us is extremely restricted.
Yes.
There are significant constraints upon us, and there are significant constraints upon you and friends who are fighting to save this tree. And you are seeing that in your actions before courts. Now, I just really want to get a sense from our team. There is a suggestion that we should be party to the proceedings in the High Court.
Yes.
That's your request here today. Now,
As well as consideration of the SCA reinstatement.
Yes. So I just also want to check from Mel's. Mel's, in your presentation, if I heard it correctly, you said in that presentation, I don't think we need to go back to that slide, but you said that the court is unlikely to uplift the enforcement because the council hasn't put in place an SCA. So are you saying that the test is going to be before the court then?
I can't say what the court is going to do.
No, but sorry, can you just, sorry to rush you, but to go back to that statement that you made, you said that the High Court will not uplift, you're prejudging the court in some ways, but you're saying your expectation is the High Court will not uplift the protections because the council has not made the step towards putting the SCA in place.
My anticipation is that because the Environment Court ruling gave clear indication that the remedy to protect this particular tree was to use the legislation that existed to do a plan change to replace protection on the tree. That's what the direction, if you want to call it that, from the court said. That if there is no move towards that by the council, then it's very likely that the appeal against lifting the protection order will fail, because there will be no route to permanent protection. So why would they keep an interim protection order in place if there's no route towards installing permanent protection? And, you know, the permanent protection is within the gift of the council. It's not within the gift of the court, because it's council processes.
I just want to test something with our staff here. I just want to ask Director of Strategy if we have a place to being a party to the High Court action. Now this is planning advice as opposed to legal advice, so it might put the Director of Strategy in a bit of a spot, but we have canvassed a lot of different options and a lot of ways that we could move towards protecting this tree and the roadside trees. I think the roadside trees are protected as you've had outlined. The key tree is the Awhiawhi tree. So in terms of the Awhiawhi tree, is there opportunity for Auckland Council to participate in the High Court action? And if so, could we assist in that process in any way to lead towards the protection of the tree?
So the original Environment Court application was by private individuals to put an enforcement order to stop the removal of the tree. The Environment Court then ruled, and then the appellants then appealed to the High Court, which is where we're at. And the High Court said, until we consider whether that Environment Court decision was correct or not, we will put an injunction so that the tree can't be removed until we make our decision. So council has not been a party to the Environment Court decision in that sense. It wasn't something we were seeking. And so from a planning perspective, my recommendation to you is that we would not be a party either to the High Court proceedings, because they're not something that we have been a party to or sought to achieve.
You could seek leave to become a party, and we would support you doing that.
Carry on with the questions and ask Member Namani.
Ngā mihi nui and acknowledgements to you, Chris, on behalf of mana whenua Kaitiaki in relation to this. I've just got a couple of questions first, but I reserve the right to speak to the matter. And when the matter first came up, one of the key concerns that we had was the extent to which mana whenua Kaitiaki were engaged in the process at the outset. And there were some failings, if I recall, around the consent process and non-notification in relation to that. So I want to know what engagement has happened with mana whenua and Kaitiaki through this process in an attempt to find resolutions to this. And then I think the second question relates to the Kodi on the road reserves. And I noted that the process that was identified and that a consent may be notified there and outlined the process. Are we in a similar situation with those two on the road reserve as we were with Awhiawhi? Because what I don't want to happen, before I kind of talk to Awhiawhi issue, what I don't want to see is another flaw happen in respect to those road reserves as it relates to engagement with mana whenua. And I didn't hear any assurance in the process around the two on the road reserve that that has been addressed and that mana whenua will be engaged, whether it's notified or non-notified. I just want some comfort around that. Hopefully I've made sense.
Thank you, Member Namani. No, absolute good sense. Thank you. Director of Strategy, could you respond to that?
Sure, thank you. Through the chair, your first question around the process with and iwi engagement through that, I don't know it well enough to be able to answer that question, I'm sorry. I know there has been some, but I don't know when and where or the kind of detail that you're asking for. Your second question about a possible, if there was ever a resource consent for the trees on the road reserve, yes, we will ask for Māori iwi's views and engage on that to determine A, whether it's notified and or B, whether it is approved or declined. That's part of the resource consent process.
No, that's great. That's great in relation to the road reserves. I'm not saying it's a solution, but it's one key thing I want to make sure of this time round, that we are engaged at the appropriate time, not after the fact, which I had assumed something like that had happened with Awhiawhi, and we don't want to repeat that that process error. If you don't know the engagement that's occurred between mana whenua and council, who does? Because it's a piece of information that I really want to know, because certainly I will defer to Chris if nobody here knows what the engagement was, but I just wanted to get a sense of has that conversation played out appropriately? And I do ask that because I don't take lightly when mātauranga Māori practices like rahui tapu are placed on areas, and I don't take lightly the responsibilities that this council has under the treaty that are articulated in the Auckland Plan. And I want to ensure that the spirit in which we're engaging with mana whenua is in line with what we say. So that's why I need to know more about that. But if Chris is able to answer, I'll give-
Chris, can you respond to that in terms of what relationship you've had with Auckland Council staff as mana whenua representative?
Kia ora koe, Leanne. I can share this with you personally. So Ngā Maunga Whakahi o Kaipara is the post-governance settlement entity in the Kaipara, which involves our marae. I know not if there was any consultation there. In 2015, when the first occupation happened with Michael Tavares, I had occasion to speak to Ngāri Blair, my cousin, and I will say that this is a conversation that we had. And I asked him if he was informed, and he said yes, Ngā Maia, which is the Environmental Protection Unit of Ngāti Whātua o Ōrākei, was asked for comment. And their reply was, if there is any native vegetation on that property, we want to know what it is. 3 months, no answer from the council. That's what I was told. And Winnie, from next door, has something to share as well.
Sorry. Thanks, Chris. Just when the resource consent for number 40 was applied for, 7 different iwi were written to and given a timeline to reply, and the letter stated there was to be vegetation clearance. Nowhere did it say it was a kauri of substantial size. A number of iwi asked for follow-up. As I understand it, they were just told it was vegetation. But what I do know is that we sent Dr. Mark Bellingham's ecology report to these iwi, and Lucille Rutherford replied, and she wrote to council and said she objected to the felling of awhiawhi. And she was told she was talking about the tree on the wrong site. And it clearly stated 40 Pataroa Road, and she was misled by council's reply, telling her that the tree on 40 Pataroa Road was actually on 42, and that consent had been granted. And I think that's the confusion that came up when we came in 2015, and we explained that. We talked to that, and council were not forthcoming with the fact that it was a substantial kauri, and that Lucille Rutherford, Te Tahu, I think it was, she objected. Thank you.
Thank you.
Good. Thank you. Councillor Clow, just before we do, look, we've been considering this for an hour. I think it's important to air this and air it well. As I said earlier, I've had a number of meetings with Councillor Cooper and Councillor Hulse on this, but if there are others that want to air it now, that are members of this committee, please do so. So, Councillor Clow.
Thank you. Steve, we acknowledge your loss, Councillor Casey and myself. As a resident of Titirangi, I've been, for over 50 years, I've been either running around Putaroa Road or leading a dog around in more recent years. I'm pretty damn horrified about any of those trees being removed. And I hear what you're saying, Megan, about being cautious about the tree on the private property. So I just want to talk about, I just want to answer in plain language about the 2 trees that sit on the council reserve. Surely we can protect those trees. Surely we can be a strong party, if not an override, to ensure that on that reserve those trees are protected. I mean, it just seems amazing, given all the money we're pouring into kauri dieback prevention, etc., and we're losing trees head over heels, and including this area is particularly bad, as Mel's has mentioned. Could you just comment in plain language about our rights and our ability to protect those 2 trees?
Through the chair, look, I think there's two ways that we've protected those trees. One is through the unitary plan, to say you require a resource consent to remove any tree on the road reserve. The second element, of course, is that we have control as both a council and AT, Auckland Transport as CCO, to more strongly influence what happens on the road reserve, because it's our land. So I think, in my view, there's two elements there. With all of these, though, whether it's the road reserve trees, trees on private land, all of that kind of thing, under the Resource Management Act, unless it's a prohibited activity, and there are very few of those anywhere in New Zealand, there is always the right to go for a resource consent. There is always the ability to do something that the rules at face value say you can't do unless you do a resource consent. So I guess all I'm saying here is that there's at least two ways which we protected them more than any other way. But secondly, it is a normal to have the resource consent process to look at case-by-case situations, and that's no different for the road reserve than it is on private land.
Can I ask, is there any assurance that we will be doing everything possible to retain those trees?
Yes, I can give assurance as far as I can, and I'll certainly talk with our Auckland Transport colleagues as well. I'm unaware that there's obviously any plans that we have, and should a private person come to us to remove those trees for development purposes, then I absolutely give assurance that we will very strongly consider and look to perhaps redesign or whatever might need to happen if it was for some relevant development purpose.
Well, just on that, I think we'll get a formal notice through to Auckland Transport as the authority and the road reserve, letting them know of our interest in those trees. So we'll put it on record.
I don't mean to be cynical, but sometimes Auckland Transport don't seem to have the same attention to the details and concerns that residents or us as councillors may have.
So we'll follow up with that formal notification of them from our planning side. Councillor Watson.
Thank you, Mr. Chair. Probably a question for Steve, I think. Given the public profile of this case and probably what it means for not just the people that have been involved but the wider public, I'm interested in what the council can do rather than what it can't do, and I take on board all the qualifications that we've heard the officers refer to. So I just want to check two things, because it's been quite hard to follow all the sequence of events. It's quite a story in itself. So question number one, as far as the appeal goes, am I correct in saying that without the inclusion of an SEA through a plan change, the appeal will have no chance? Is that right?
I think without a clear indication from the council that the council is interested in finding a way to save the tree, then it's going to be difficult, very difficult for us in the High Court. And that includes the SEA, that includes any other measures, explicit measures that are taken by the council to find a way. And really, I believe where there's a will, there's a way to save this tree. And the other point is completely gone out of my brain.
And the other question I was going to ask you, Steve, you mentioned about the current proceedings. You suggested that if the council was to seek leave to be part of proceedings, then that would be agreed to by the...
We would appreciate that. It's very difficult. There's been a lot of personal investment on the part of Winnie and Charlesworth and Andrew Mull to fight this through court. We have a Give a Little page. We need to raise $20,000. We've got $5,000. It's a very costly process, and being sure that the costs put against those people who challenge these legal determinations, it makes it a very difficult thing for a public community group to test these things in court. With the support of the council, not financially I'm suggesting necessarily, but with the support in terms of principle of testing the correctness of that resolution of the Environment Court, that would help. That would help, and that would help to keep the existing protection in place, which is the injunction, which is only temporary. The next 3 months are crucial to keeping this tree standing. Whether that a High Court case will be able to be continued hangs in the balance, to be honest, because of the cost that will be borne by the people taking that High Court case. And I do want to reiterate Mel's point that the determination of the Environment Court was that law change or plan change were the remedy. And whenever we've mentioned plan change, we get told it's too hard, it takes too long, it's too expensive. This is the message we get back from council, including from my conversations with Councillor Cooper and Councillor Hulse on this. And so for us, it's sort of like, well, what the heck can we do? You say that the court says the problem is the plan, the council says we can't change the plan, you know, so we go to the High Court and say, well, let's check whether this is actually correct, that the problem is the plan. And the council, we're saying now, well, join us in checking this. Let's actually test this finding of the Environment Court, whether it is simply the only remedy is plan or law change. And all the while, we would like you to make the plan change and advocate for the law change to bring back a blanket tree protection, advocate to central government to do that, yeah.
In addition, I'd just like to say that you have a plan change that's on the table, and whilst you might say that as it stands at the moment, the scope is only for the schedule, it's in your gift, councillors, to change the scope of that plan change. It has not been publicly notified yet. It is up to you to decide what the scope of that plan change is, and if you want to save public money and get the best bang for your buck in terms of protecting trees across the region, then as per our letter, there are many things that you could be adding to that plan change on trees that would make it better for trees that already could be protected in this region and are currently not protected and are being cut down hand over fist. So within your gift, to do something with a process that is currently in place and get good value for money and get better protection for the trees that are already here before we lose them. And that includes Awhiawhi.
So final question, just to really through you, Mr. Chair, and thank you for allowing the questions to continue in the way you have. Given the prominence that this matter has attained, and I would suggest that the sequence of events as has been outlined to us, what consideration do you think should be given to council's reputation in this if it isn't seen as doing everything it possibly can to provide a response in the manner that we've been requested today? And I ask that to you because clearly after the presenters have gone, it'll largely be, I suggest, in your hands as a chair of this committee, how we might conceivably proceed.
And it's been in my hands and the chair of the Environment and Community Committee for a long time. We've had deputations in the past, and it has been well looked at. There has been no shortage of attention given by myself as Chair of Planning and Councillor Hulse as Chair of Environment and Community Committee on this particular matter. We have had numerous meetings with the staff. We've gone back with further questions, and there are further questions being raised here today. They can't be answered here today, and one of the questions really needs to be taken up with our legal team, which couldn't be here today. So that is the question of how possibly we could play a part in the High Court action. We've had a planning response. I need to get a legal response on that now, and I will ask for that this afternoon as soon as this meeting is concluded. It has been, at the last time we considered this, we talked about the notable tree status and how we could review that. Well, at the Planning Committee, Councillor Walker, you moved that the notable trees be considered by the incoming council under the wider context of the urban Ngāhere strategy. Councillor Hulse has a huge body of work to protect literally thousands of hectares of trees in Auckland. And that is a massive focus of the council. And that work has been well informed. It's had a long lead-in time. It's extremely well structured, and we're embarking on that work. We're talking about effectively one tree here. I'm confident that the 2 roadside trees we have got adequate protection measures over. We're talking about the great tree Awhi Awhi. There is no shortage of commitment from the council and the staff, the politicians, all of us, to do everything to protect that tree. And at the moment, if we have not exhausted all means, we will make sure they are exhausted and, if possible, find a way. That is my commitment. That has been the commitment of Councillor Hulse and Councillor Linda Cooper. We will carry on.
So thank you for that. So just to check then, you're going to clarify with the lawyers the legal position in terms of seeking leave to be a party to proceedings. That's going to occur this afternoon. And as far as the SCA plan change component, we could do that if we have a mind to, even though we're told it wouldn't necessarily prevent the individual from removing the tree. Is that right?
So on 2 counts. On that count of checking whether there is scope, we've been told, and we've been told that through a memo that was distributed last week. I didn't get any feedback from that memo, but look, it's for discussion right now, and I will check that again. I need to check that with legal very, very closely, and I will check this afternoon with legal whether there is scope to participate in the High Court action, which I understand is before the court actually hearing on the 19th of June, which is not too far away. Now, I'm very mindful of the time. I think we've not quite exhausted, because you say exhausted when you're at the end, and I think we're not at the end. But Member Namani, did you want to reserve your right to speak, or did you have another question?
If there's a way forward and the commitments that you've made for us to look at what we can do, then I'm happy to kind of have that conversation with you and follow that through without making statements right now. Okay, and I suggest as a way forward, the members of this committee that are interested, Member Namani, of course, Councillor Hulse has been engaged, and Councillor Cooper and myself and Councillor Clow, anybody who might be, we can convene a small group and we will together literally grill the staff on this one and see if we can uncover any other opportunity that we haven't uncovered to date. Mels, I do need to move forward now. I think we've heard from you well. We've heard from all of the parties, so I need to bring this to a conclusion. Now, Councillor Casey has provided a motion. Councillor, the first motion is unfortunately out of order. You're okay with that? The second motion, I'll read it, or do we have it typed and I'll put it up? Councillor Casey, are you okay for me to put it up now? And so we'll receive and thank the presenters. Chris Pairama on behalf of Te Tio and Ngāti Whātua, and also Mels Barton on behalf of the Tree Council, and Steve. We'll thank you all, and we do really reach out to you and say thank you, and we receive all this information, and we are as passionate. No, I don't think we're as passionate, because you are enormously passionate. We're just passionate at a slightly lower level, but that is only a reflection of your enormous commitment, as I explain the difference between
our passionate approaches. The second part that is presented from Councillor Casey is starting to look at all those options, which is some of the things that have been articulated here today. So we will work further on this. And
Councillor Darby, can you ensure that Councillor Casey and myself move and second this, given we put up B as an amendment, please?
No, Councillor Casey is moving the A and the B, and you're seconding. That's what I've got. That's fine. Okay. So, Councillor Casey, I'm wondering if we could bring this to a conclusion now. Councillor Walker, have you got a question?
I've got a question and I'd like to speak to B.
Okay, question first, please.
Okay, and my question goes to the memo. The memo doesn't rule out a plan change. The memo simply says that it's difficult because the plan change would need to be more than just this tree. Is it possible for the council to put some form of motion indicating that this tree would be included in a future plan change? And the reason I ask that is that that would send a clear message to the court that this tree is going to be protected. And I state that because of the information that has been provided, that the action of the court, or the thinking of the court, is around that future protection and the likelihood of it. Is that possible? Can we do it? And if so, how quickly can we do that?
I'll ask the Director of Strategy to reply.
As I said earlier, the issue is that a certificate of compliance has been issued for the removal of the tree. There is nothing, no plan change, no nothing that can trump that. So even if we did a plan change and it all happened tomorrow, it would have no impact on the ability, once any High Court matters have been resolved, for that tree to be removed. I'm not sure how more clearly I can say that.
That's not my question.
No. So the second element, I think this is part of the report in B and the comments made by the chair in terms of options. We tried to make that clear, but this would be part of the optioneering in the sense of what options there are, and the committee could instruct us to do a plan change if that's what you wished. It would be a public process. It would take some months, the normal kind of public process to go through. Notwithstanding, it would have no impact.
My question was whether this council can put a resolution to the effect that this tree would be included as part of a future plan change. Can we do that?
So if you support Councillor Casey and Councillor Close B, then we take a report, then we have that information before us, and we can make that call. That is the process. We don't have that information before us today.
I would have thought my question was pretty clear and pretty easy to answer. Can we do it?
Look, Councillor, I think I've just given you the answer, but look, if you...
Well, given this is a public input matter through the chair, no, you can't right now. You can request a report, which is what is being done with A and B.
And how quickly can we get a report?
Well,
we will consider that at the conclusion of this meeting, and as I just said, we will convene a group of interested members of this committee to discuss this matter further. And if the motions are passed that Councillors Casey and Clow propose, and I'm not expecting them to fail, then we'll be considering a report at the earliest opportunity. At the earliest opportunity, yes, you can take those words. Councillor Casey, would you like to briefly speak to your motion, please?
Yeah, I'd just like to thank everybody for coming today. There were shades of Ihu Mātou here for me. You can say, oh, if you like, I'm speaking from the heart, Bill. It feels like, Megan, you said there's nothing we can do and nothing we should do. So, okay for the first part, but the second part, no, there is something we should do. That's why these people have come here. they've said, you know, I know that you've looked at everything, but there must be something that we can do, and that's what I heard. Chris, thank you. It's what you've told us today is that Mana Whenua want to save the tree, that science wants to save the tree, because we need to look at what happened here. It's an amazing tree. Afi Afi deserves to survive, full stop. We didn't know that until we went through this process. So what you've done today is say to us, you're our elected members, what should you be doing? So it's not, we can't do this, it's what should we should be saving the tree. That's it, full stop. And we're your last port of call after, you know, we're in charge here. So if we tell you no and go away, nothing's happening. But now we've got something happening. So thank you very much, Mr. Chairman.
I know you're trying to...
So no, I can't take any more. I can't take any more input from the presenters. We're now into debate. Thank you, Councillor Casey. I think we've canvassed this well. But Member Namani, you signalled you'd like to speak to the motion itself.
I just I support the motion, so I don't need to speak to it. It's been articulated.
Thank you. Now, I just want to make sure we're acknowledging Mel's and Steve here as well. My apologies, there was no oversight. It was just a matter of putting the words together. Thank you, Councillor Casey. Thank you, Councillor Clow. I will, there are the words, and I'll... Yep, we're just tidying it up. And thank you all. A good examination of this. More to come. Thank you, Chris, Mels, Steve, and all those that sit behind you as well. Thank you all. I will put this to the vote. All those in favour say aye. Aye. Contrary, no. Declare that carried.